Good afternoon, everyone. Welcome to this week's coronavirus webinar. My name is Kathy Purdy. I'm a marketing manager here at Schoeneck King. Just two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and we will do our best to answer those as time allows. Once the webinar has completed, if you would take a moment to complete the brief survey, we would appreciate it. We do share your comments and suggestions with our presenters for future topics. So to start today's program, I'm going to hand it over to Pete Jones.
Thank you, Kathy, and good afternoon, everyone. It's good to be with you again. I thought I'd take just a second today to offer a little bit of perspective. We started these weekly Tuesday webinars 1 year ago, I think 1 year ago tomorrow. This is our 53rd Tuesday COVID related webinar. We had our first one in person, actually across our offices with people attending. Seems hard to believe now that we actually did that, but it was early days, and you know there were really no cases. The first case was reported, I believe, a year ago today, and so at that point, people were just trying to get their heads around how this was going to impact us. We've averaged approximately 850 people on this webinar per week. That's around 45,000 attendees. We really appreciate you being with us over the past year. Since that time, we've explored potential disruptions. We've had worked through shutdowns. We've worked through reopening, and we've seen the rules change. We've seen them morph. We've seen the science advance and the thinking change throughout this period. But we've worked through it together, and we appreciate you being with us. I think as we get to this 1 year mark, we see a lot of signs of hope. We now have 3 vaccines approved. We're going to talk a little bit about that today. There are better treatment techniques, and we've got spring and summer around the corner, which hopefully will also bring some relief. Of course, I think we've learned that you're going to get a curveball or two throughout this situation. And so we'll be there for you to work through it. Our hope is that soon we will no longer need these webinars, that we'll transition this into maybe a weekly webinar on just legal issues that won't be so COVID focused. But until that time, we're going to continue to be there with you and work through it with you. With that little bit of perspective, we'd like to start today with Stephanie Fedorka. Stephanie's going to give us an update on the relief legislation and where we stand with that. Stephanie?
Thanks, Pete. Thanks for joining us today, everyone. Happy to be back and be on and share a little bit of what we know so far on our first review of the relief legislation that is moving through Congress as we speak. So the latest is the House has passed a new relief bill. There was no Republican support in the House, which is interesting because the Democrats are using a strategy known as the budget reconciliation process. So they're using it to try to push this legislation through as quickly as they can without receiving, and not needing the Republican support that would normally be required to pass certain legislation. So here's a little bit of information. It's sitting now with the Senate. We don't anticipate that any Republican senators will provide support, but not necessary. Using the budget reconciliation process, the Democrats only need 51 votes in the Senate, so they need all of the Democrats to support it, plus Vice President Harris to be the tiebreaker. It's $1.9 trillion in this relief bill. And there's a huge push to pass by March 14th. The reason for that date is, if you recall, there's the unemployment insurance benefits that were passed, that extension in the December relief bill, and those expire March 14th. So there's some unemployment insurance benefits, additional extensions in this relief bill. So they're trying to push it through so that there is not that gap for individuals who may, are still unemployed, and try to minimize that disruption for citizens. Next slide, please. So here are some of my highlights. It's not an exhaustive list of what's in there. It's about 600 pages. But on a first glance, I think these are the things that I picked out that you might want to know about. So obviously, stimulus checks are the big one, $1,400. direct payments for individuals with certain caps as to who's going to be eligible for that. And I think it prorates, if you make more than those numbers. The couple, obviously it's $1,400 per individual. So for couples who join together or file jointly, I apologize, it's $2,800. And then eligible dependents, there was also a little bit of an expansion on that. I think some adult dependents are now eligible as well, the $1,400. The minimum wage rate raised to $15, which has been a hot topic. It's still technically in the bill itself, but it's reportedly going to be removed due to Senate rules. So using the budget reconciliation process, you can only include provisions that change spending or revenues. So we are anticipating that that's going to be quickly removed from the bill. Next slide, please. Paid family leave. So hot topic. I think there's more to unpack with this of what we know, but it's going to be an extension of what we're currently working through right now, that voluntary extension of the FFCRA style leave. So it's not going to be required. The tax credits will be available to employers who elect to offer these paid leave benefits through September 30th. No new allotment of FFCRA leave ? There is some language in there, so there should have been a question mark there. I apologize for that. There is some language in there about a reset of number of days. So we've got to unpack that a little bit more. So if you tune in the future, we will definitely have that fleshed out for you. I'm sure we will have more details as we move through, the Senate, and perhaps there are changes that we may see as well. But again, employers are not required to provide it. It's completely voluntary. There is an expansion of the employers that could benefit of this. Certain government employers may be eligible to reap the tax credit benefits. So we'll definitely have more on that. Next slide, please. Extension of UI benefits, currently set to expire March 14th. As I mentioned earlier, and it expands the federal unemployment aid through August 29th. More self-employed and part-time individuals could qualify as well. So we're seeing an expansion of the benefits available and who can reap them. Increase from the $300 additional federal government benefit to $400 in the weekly benefit bonus. I kind of call it a bonus. It's an extra amount in addition to the state benefit. And then the total number of weeks after the expansion in the relief bill in December, they were at a total of 50 weeks of benefits that they could claim. And now not now, but in the works, it'll be a max of 74 weeks. Next slide, please. Cobra continuation coverage. There's a provision in there that I thought was interesting for premium assistance for Cobra continuation coverage for individuals and their families. There's reduced Cobra premium for workers eligible for Cobra due to involuntary termination or reduction in hours. There's a plan enrollment option in there, extension of the election period, and then there's also an employer notice requirement. So it requires employers to provide clear written notices on various topics provided in the bill, and there's some penalties attached to failure to provide appropriate notice. The government will be or is intended to provide some model notices for you to use, but definitely keep your eye on that to make sure that if you have any employees that are entitled to that Cobra notice, you're including everything that's up to date, if and when this passes. So aside from that, there's a couple others. I think there was also an extension of the employee retention credit that I saw. And there's several other benefits and tax credits that have been extended as well. A lot of it really is continuation of what we saw back in the December relief bill, but definitely stay tuned and we will keep you up to date on how this progresses.
Thank you, Stephanie. A lot in that bill. Appreciate the update. We're going to turn now to something that we just wanted to bring to your attention. We have a couple of presentations, some things to keep your eye on. The first is really the OSHA citation that was recently issued out of the Kansas City regional office. This is of note because I think it reminds us of a number of things that we need to be aware of in the employment area. So let me give you the nuts and bolts first of what occurred here, and then we can walk through putting it in perspective. First of all, the facts of this particular case, and these are the facts according to OSHA. These are pulled right from a press release that OSHA issued relative to this citation. So the employer may well be disputing these facts or may have a different view of what's set forth here, but this is what OSHA believes the facts are. This is a manufacturing situation. There were two machine operators who worked very close together. They were not wearing masks. They were together typically for a number of hours per day, working in very close quarters. They tested positive, and shortly thereafter, there were two more workers who tested positive, working on similar presses under similar conditions. Ultimately, one of these individuals contracted, got very sick with the virus and ultimately passed away. Now, this next bullet is interesting to me because OSHA made a determination, at least to a reasonable degree of medical certainty, those are their words, that the deceased employee contracted the virus while on the job. And this has always been one of the things that we'll talk about whenever we're talking about, COVID liability cases, is the causation question, whether or not it's established that a particular exposure resulted in the actual contraction of the virus. And so in this case, we've got OSHA with a special medical determination saying, yes, we think that's the case. And of course, the facts as portrayed here would suggest that because of the close quarters and the lengthy contact and the fact that we've got multiple people testing positive. You can imagine that in a number of other situations, the facts would be very different and causation would be very tenuous. Even in a case like this, there certainly would be arguments that the exposures maybe didn't occur at work. Perhaps the virus was contracted other places. In any event, the OSHA local office ultimately went ahead and cited the employer under the general duty clause. That is the clause that says the employer must maintain safe working conditions generally. So not a particular OSHA standard, but the general duty clause, and indicated that the employer failed to fully implement and enforce the use of feasible controls for employees to prevent the spread of the virus. Company failed to implement use of face masks and social distancing throughout the workplace until after the death of the employee. So in this particular situation, fines were issued, one a record-keeping fine, another for the underlying violations that the local office has found. This matter could be appealed, it could be resolved. And so this is not a final determination, but this is sort of an interesting case study for all of us, because it comes back to the idea that it is possible that the employer's processes, protocols, and how they've implemented those can come under scrutiny from OSHA, especially if you've got a lot of cases in a confined area that suggest possibility that transmission at work may be at play. So on the next slide, we're going to talk a little bit about trying to put this into context, okay? And this is a slide that we've actually used previously to just try to summarize where we are. Remember that employee claims generally, claims by employees relative to workplace exposures, workers' compensation should be the exclusive remedy for injuries that are sustained at work due to an exposure or an accident in the workplace. But that is not, although it's exclusive to tort claims and negligence claims, things like that, that doesn't mean that there may not be other theories under which the employer can be liable for failing to follow safe policies in the workplace, or having employees raise issues relative to the coronavirus. And number one is OSHA, the case study that we just saw. Also, there's a possibility that people might bring an ADA claim and say, you had a duty to accommodate me that you didn't legally discharged, that you were, didn't accommodate my disability, and that has resulted in some sort of harm to me, even if it's not a workplace injury, under the workers' compensation law, there could be damages associated with lost pay or lost opportunities if disabilities are not accommodated or if disability discrimination is found. We've got cases that would deal with leave entitlements. The idea that people are entitled to many forms of leave, or at least have been throughout the pandemic, and so you might get people saying, well, even though you may not have liability for an unsafe workplace or for a workplace injury, I've got these kind of claims because you didn't give me the leave that I was entitled to, especially when people are quarantining or being held out of work. And then lastly, retaliation claims, that we may see people saying that they've raised a safety issue, or they've raised issues under the ADA, or they've raised issues regarding leave entitlements, and they subsequently received what they think is discriminatory treatment for having raised those issues. In addition to those kinds of claims, we've also got this really what I would call third-party investigations into compliance issues. The Attorney General complaints were a feature at the very beginning of the pandemic. We saw an awful lot of this with the Attorney General in New York saying, if people are not following the protocols, please bring them to me, and we'll follow up. I think that activity's calmed down a little bit, but it still remains certainly a viable alternative. And then also the prospect of independent actions by individuals or labor unions. There's also the potential for third-party exposure claims. If workers' compensation is generally going to be the remedy for your employees' exposure in the workplace, if you are negligent with respect to your protocols, or you don't take care with respect to third parties, there is the possibility that you might get an exposure claim from a third party saying, your conduct as an employer ultimately subjected me to injury and damages. So it remains true that our best approach in terms of defending these claims is to have a plan, a workplace safety plan, a protocol, and to follow your plan. That means that you will have thought through these issues and you're implementing the best practices that are available to you. And in that kind of a situation, generally that's going to be a defense to all these kinds of claims. And the last point I'll leave you with is that causation will always be an issue in these cases. As we saw in the OSHA case that I just talked about, causation was determined by OSHA, at least at the investigative stage, based upon the facts of the case and in consultation with some medical experts internal to OSHA. That may not be anywhere near as clear in a lot of the other cases that we're thinking about and talking about. So that's a brief update on the employment litigation issues with a little bit of emphasis on a new development that we'll keep our eye on at OSHA. I want to turn now to Jen Schwarzout. Jen is in our litigation group in our Rochester office. And, this is really part two of things to keep your eye on. Jen's going to offer some thoughts on COVID litigation generally.
Hi, everybody. Good to be with you today. I am going to kind of pick up right where Pete left off in talking about some of the reasons why you might see some more of these claims or less of these claims, and talk about them in the different categories. Pete obviously went through the different employment-related claims. For similar reasons, that has had there will be an impact on personal injury claims. So traditional personal injury claim we can think of as someone has been injured and they're seeking compensation for that injury. It's called a tort or negligence. Those of us who went to law school know that you spend a whole year in law school learning about torts. But the tricky part here is in the COVID world, for the same reasons that Pete explained with regard to causation, that element is fundamental to establishing a personal injury claim. So I think at the beginning of the pandemic, people were concerned that there would be an overwhelming number of personal injury claims related to COVID. And that hasn't happened yet. And the causation has big part to do with that. Unlike the workplace situation that Pete described in OSHA, if you, let's say you go to the gym, or you go and get a coffee at Starbucks, and you're doing the precautions, and then you drop your kids off at school, and then you wind up with COVID 3 days later. Well, figuring out how exactly you got COVID is going to be a tricky question. Maybe your aunt had COVID, maybe you had a friend over and you thought you were social distancing appropriately, but she turns out to have it, or maybe the Starbucks worker had it, but it's just narrowing that down with any specificity makes a real challenge to proving these claims in a personal injury context, as well as from a duty context. And the concept of duty is very boring, so I won't spend too much time on it. But in order it's essentially a predicate to having a personal injury lawsuit, you can only sue someone to whom a duty is, you have to have a duty owed to you. So someone walking by you on the street, for example, there's no duty to protect. Workplace is different, right? Or an invitee, if you go to an event space and they've proclaimed to have safe space, that could be a little bit of a different situation. But that really is why I think, and I've talked to a number of folks who typically bring these types of lawsuits, and that has been a real impediment as far as they're concerned. In addition, the damages, as everyone knows, really span from minimal. Some people have minimal symptoms, some people have significant, and then of course there's horribly, some people have died. But for the transitory flu-like symptoms, those are not typically symptoms that people would initiate a lawsuit for because they go away most times, is best we know from the science. Now, maybe that will change in the future, but that's what we understand. And so that, with the exception of the nursing home context, which I'll mention briefly, there haven't been a lot of nursing home cases yet either. That is in part, one, for the reasons I just discussed. Although in the nursing home context, you can imagine if a patient is not leaving the home, there could be a potential that would be an easier to establish an exposure pathway. But there has been an immunity passed at the beginning of the pandemic that was legislated for immunity provisions for hospitals and nursing homes. And so that is still in effect and will continue in effect until the emergency declaration stops in the state of New York. So that is a bar to those types of claims coming forward, at least at this point. There is certainly investigation and a discussion of whether that immunity provision will be repealed at some point, but that has not, it's been modified, but hasn't been repealed, at least as of yet. And then, so it's fair to say that the trend with those personal injury type claims has not been extensive, but there is a 3-year statute of limitations for negligence claims in New York. So those could come forward heretofore, but so far they haven't been too explosive. The claims that have been, the most claims that have been brought in New York have been for business interruption. So businesses who had to close because they have been fall under one of the governor's orders to close, have filed claims. Initially, they made claims against their insurance companies if they had business interruption coverage. In many instances, those companies disclaimed that coverage, and now those matters are being percolated to a lawsuit. So the insured, the company, is suing the insurance company to say, we do, this coverage should be triggered, and we want our money that was promised to us in this insurance policy. And those claims were really, as I said, the most that have come forward in New York. And that trend has gone down, and that would be what you would expect. And that's because now businesses are starting to open back up. So those types of claims, although they've been the bulk of the claims to date, are kind of trending in a downward fashion at this point in time. And that makes sense, kind of where we are on the pandemic horizon, I suppose. The other group of litigation that I think is forthcoming would be claims related to PPP loans. So there is a process, as many businesses know, and many of you on the call, if you've received those PPP funds, there's a forgiveness program. And it's possible that if your loan isn't forgiven, and you believe it should have been based on the criteria, that those claims will start to uptick. That's kind of a future trend, I think, that we're waiting to see on, but it hasn't quite hit just yet. With regard to the employment-related claims, and Pete did a nice job of going through those and the different types of claims that would exist in that space. The trend has been interesting, I will say, and based on there's a number of services that kind of do the tedious task of going through and looking at every complaint that's filed in the state of New York in both federal and state court. And those organizations have suggested that the initial trend from March of 2020 till February of 2021 has trended fairly low, but since January of 2021, the employment-related COVID claims are actually on the increase. And that's interesting. And those relate to leave accommodations, workplace safety. Certainly, the specific case that Pete mentioned would certainly suggest that maybe now, if OSHA's taking that position there in that case, maybe that will be something that we'll see more of in other places. But the COVID-related discrimination and wrongful termination claims are actually trending up. This is a little bit of a puzzler, I think, because you would think that some of those issues would have been more challenging when every places had to close in the beginning. But I'm speculating here, but I think it's certainly now the case that employers are having to make more difficult decisions. It's one thing when your business is told you're in a specific zone and you can't open. Well, sure, everybody's closed, right? But if you are now making a judgment call, whether someone actually qualifies for a reasonable accommodation, whether they don't, whether they're staying home for alleged COVID-related reasons that you don't believe, and maybe they're terminated. So those types of judgment calls, I think, are happening more and more and probably will continue. And so it's suspected that that trend, at least over the next few months, will probably continue in those employment-related litigation claims. So, you know, as litigators, we always say there's always a risk of litigation. And so to Pete's point, it's good to make sure that you're speaking with your attorneys to make sure your plans are in compliance. But it's fair to say, too, that claims are probably less, at least in New York, than initially was suspected, which is certainly a good thing for business owners. So with that, I'm going to turn it back over to you, Pete. Thank you.
Thanks, Jen. I appreciate that. We're going to turn now to Adam Masterleo. I see a few questions in the chat that have already anticipated your presentation, Adam. So take it away.
Well, Pete, I'm glad we're doing this today. We thought it would be helpful to provide everybody with a little update on the travel quarantine requirements and how, if at all, those quarantine requirements have changed in light of the vaccine. So as everyone knows, we're now seeing many, many more New York State residents who are becoming vaccinated, and questions are naturally arising about, okay, I have the vaccine, now what are my requirements? Can I go out and do whatever I want now? Do I still have to quarantine? And there have been some modifications that we're going to talk about now, specifically in the travel context. So first, I want to start with where we were, or where we are, where we were as of the end of last year. So in November of last year, as everyone knows, New York State updated its travel guidance and put out some new quarantine requirements. These new requirements said that if you were an individual who traveled to any non-contiguous state, so any state other than Massachusetts, Vermont, New Jersey, Connecticut, or Pennsylvania, and you were outside of New York for greater than 24 hours, when you returned to New York State, you had to do a couple of things. You had to quarantine for 10 days. Well, at that point, it was 14 days from the date of return. However, the state said you could test out of that 14-day quarantine period if you received a test within 72 hours of your return to New York, and then on day 4 of your return to New York. So we had those procedures in place. Also, you were exempt from the travel quarantine requirement if you were an essential worker. There were certain other exemptions discussed in the travel quarantine document. So that's where we were at the end of last year. On December 26th, the State Department of Health said that the quarantine period was no longer 14 days, but it was reduced to 10 days. So the baseline is if you travel out of state to a non-contiguous state or an international country level 2 or higher, and that includes Mexico. I know somebody asked about Mexico. You have to quarantine when you return for 10 days, unless you follow the test out procedure that's in the guidance, or you're an essential worker. So that's where we were at the beginning of the year. On February 10th, the CDC came out with new guidelines that said an individual who was quote unquote fully vaccinated could avoid the quarantine requirements that were previously recommended for someone who had close contact with a positive case. So the CDC said that if 3 things were present, if 1, you were fully vaccinated, which meant that you were 14 days after your second dose, if you were taking a vaccine that required 2 doses, or 14 days after your first dose, if you were taking a vaccine like the new Johnson & Johnson vaccine that only required 1 dose, you were fully vaccinated, number 1. Number 2, the exposure was within 3 months of when you were first inoculated. And number 3, you remained asymptomatic since the exposure. So the CDC was saying if all 3 of those criteria were met, then you didn't have to quarantine under their recommendations if you were exposed to a positive case. The next day, so February 10th, the CDC came out with its guidance. February 11th, the governor put out a statement through his press room that said that the New York State would be adopting the CDC recommendations and that forthcoming Department of Health guidance would be released, memorializing the fact that we were going to be following the CDC. Now, that was February 11th. To date, we have not received any updated guidance from the Department of Health adopting the CDC recommendations. So this has naturally caused some confusion, and people have not known what to do as it relates to quarantine requirements for fully vaccinated individuals. What we saw at the end of last week was a number of local health departments, so county health departments, including Erie County, Chautauqua County, Allegheny County, coming out with their own press releases saying that we are going to adopt the CDC recommendations for individuals who are fully vaccinated. And these counties, many of them are saying that we're going to adopt these requirements for individuals who travel out of state, as well as those who are exposed to a positive case. So, this action contradicted an earlier rule that the State Department of Health had, which was that local health departments couldn't come up with their own rules that would, in theory, contradict what the State Department of Health was saying. However, it's our understanding that local health departments are being told by the State Department of Health that implementing these requirements is okay. So this doesn't provide much clarity for businesses, individuals. It's not really all that helpful. What we would recommend you do is check your county, check your local health department, see what they are saying specifically about quarantine requirements for individuals who are fully vaccinated. For example, I'm sitting in Onondaga County right now. Onondaga County has not changed its requirements. There is nothing from the county that is explicitly saying individuals who are fully vaccinated don't have to quarantine following travel. Now, to make matters even more complicated, you can check your county website, check what the county is saying publicly. The county may be saying something differently if you are privately calling them and asking them. So there is quite a bit of confusion right now as it relates to what fully vaccinated individuals are required to do following travel or following exposure to a positive case. I would say if you are a business and you're concerned about this, check with your county, look what they're saying publicly. And I mean, it may not hurt to call and find out specifically from them what they're saying. We've seen states over the past couple of days, like Pennsylvania, for example, who have removed all travel quarantine requirements. New York State certainly has not done that. The travel quarantine guidance is still in effect. We're obviously going to monitor that, but those are things to keep an eye on. Now, we had a question about what about individuals who have had COVID? So we've seen these relaxed standards for people who are fully vaccinated. What about people who have had COVID? And again, I will say that each local health department is addressing that topic differently. There has been what I can tell you with certainty is there has been no formal statewide guidance from the Department of Health addressing that topic. So again, check with your local health departments. And it's unfortunate that at this point, we don't have statewide guidance that we can lean on, particularly where the governor said such guidance was going to be forthcoming back on February 11th. But that's where we are, Pete. I wish I had more concrete answers, but really right now the answer is check with your local health department.
Okay, yes, that's clear. Could you run back through the three things that the CDC, I've seen questions on that. People like to take notes. Maybe you could just mention
Sure.
those three things again. If that is the direction that the local Department of Health ends up going, or ultimately the state issues follows that guidance.
Right. So the CDC said that three things had to be present in order for an individual to not have to quarantine following a close exposure to someone with COVID. Number one, fully vaccinated. The individual has to be fully vaccinated. The CDC defined that as 14 days after the second dose of a 2-dose vaccine, or 14 days after the first dose of a 1-dose vaccine. So practically speaking, if you got the Moderna or Pfizer vaccines, it's 14 days after your second dose. And if you get the Johnson & Johnson vaccine, it's 14 days after your first dose. So that's qualification number one. Qualification number two is that it has to be within 3 months of your inoculation. So when you were vaccinated. In other words, they're not going to allow this exemption to apply if it's greater than 3 months after you got vaccinated. That's based upon their estimation at this point of the efficacy or how long a vaccine is going to help you for. The third factor or qualification was that you have remained asymptomatic since the exposure. Because remember, the CDC recommendation only related to quarantine following exposure. It didn't discuss travel. So
Very
those
good.
are the three things.
Yeah, and I think we could anticipate there's a possibility that 90-day, the second factor, the 90 days might change if
Yes.
the science catches up.
Yep.
We're just not sure, but for right now, 90 days is what the CDC has said. Okay, great, thank you. Let's turn now to Katie. Katie Anderson is in Albany, and she's got the update from Albany.
All right, thank you, Pete. Happy to be here again. It's unbelievable that this has been almost a year, so we'll keep going on. I'll have a few things to say about that in a little bit. Looking at where we are today, we've seen the cases drop off in New York, but we're seeing a leveling that's occurring. That is significant because COVID is still fairly widespread in New York State. And this level off is of concern because, it should be decreasing. There are questions as to why the cases are not decreasing. Looking though at the variants, and this may be a reason why the cases are not decreasing in New York. There is a New York variant that's been coined in the past week, but they've been studying it since November. This variant emerged in November. It's possible that it dodges COVID antibodies in your system already. But really, this is very speculative. The research that's been done on this variant it hasn't been peer reviewed. It hasn't undergone the same level of really inquiry that's required. But science does show that the New York variant is linked. It's related to the South African variant, the Brazilian variant, and the Californian variant. All of those are linked together because they lower the basically they put holes in the antibodies. They just swerve right around them, and that's how they latch on. So that's how those ones are working. The UK variant, as you know, spreads more easily, but really this New York variant is the reason that it's speculated as to why New York has not decreased the cases proportionate to the rest of the country. But we do have good news this week. The Johnson & Johnson vaccine approval is huge news, and it's going to have dramatic effects for the state. Last week, New York received just under 700,000 doses, and this week, New York is receiving almost 900,000 doses of the vaccine. That's enormous. Johnson & Johnson is planning on delivering 100 million doses to the US by the end of June. By the end of the year, it's planning on having delivered 1 billion worldwide. So that is huge. This is a cheap vaccine. It doesn't need to be refrigerated. It's much easier to get out for people. So it's excellent news. Currently, we have almost 15% of New Yorkers having received the first dose, 8.1% having received both doses. The latest news for vaccine eligibility are public-facing hotel workers may receive the vaccine now. Hotels have been, their main source of income throughout this has been housing COVID patients, housing people who are quarantining, either because they were exposed to COVID or because they have COVID. So it makes sense that they would be eligible to receive that since they are interacting with people who have COVID. So no news update on eligibility expansion beyond hotel workers at this point. I know that's a question that many have. I know that once that phase 1C opens up, it's going to impact many of you on this call. So we will continue to be watching that closely, but there's no news on that currently. This bill passed the state Senate yesterday. This is the paid leave for the COVID vaccine bill. Last month, I reported on it when it passed the Assembly. The governor has not signed it yet, but it hasn't been sent to him to sign yet. So we expect that that's going to be forthcoming soon. What does the bill do? It requires public and private employers to give an employee a paid leave of absence for a sufficient period of time not to exceed 4 hours per vaccine injection. So that means that if an employee schedules a vaccine and it's during your working hours, then that employee must receive leave up to 4 hours to receive that vaccine. If it takes that employee, an hour, then you only give leave for an hour, but it's 4 hours. That's not anticipated that everyone's going to reach that per dose, right? That's very different, but that is likely going to be the law very soon. The governor just needs to sign it. It needs to be sent to the governor. It will take effect immediately. So as soon as the governor signs it, or as soon as it is enacted, it can be enacted other ways, but we don't have to get into that. This will be the law. And remember, you cannot penalize employees for requesting or using this leave. So that is where that is updated. I'm sure that our Labor Department will be issuing some update to break this down for you, but that is the text of the bill right there. Turning to another piece of legislation, the New York HERO Act passed the state Senate yesterday. It has not passed in the Assembly. It hasn't even moved in the Assembly, but I just wanted to bring this to everyone's attention because there is a chance that this could be coming through and create an additional thing that you have to do. This would require the New York Department of Labor to create an airborne infectious disease standard that would cover all private employers. Using that standard, employers must then adopt a safety plan for their workplace. Really, this is meant to address the spread of COVID in workplaces and to require safety plans in place to prevent its spread. It also allows for the creation of a workplace safety committee where at least 2/3 of the committee would have to be non-supervisory employees. Really, it's unclear what this committee would do. Part of most of this bill is actually giving power to the Department of Labor to set standards. And so we obviously wouldn't have those standards yet because the bill hasn't passed. So we will continue to watch that closely, but please remember, this has not gone anywhere, right? This has passed the state Senate, but it has not moved in the Assembly. So we just wanted to bring this to your attention as something that could be coming down the pipeline. And finally, we've seen some really rapid developments surrounding the governor, and all of this is occurring during budget season. The state budget is due in 29 days. There are big questions that need to be answered in this time period. Marijuana legalization, for example, that has been one that's receiving tons of press coverage, but even things like school funding, that's taken a significant dent in this proposed budget. And how will that change? This is all complicated by the fact that in the past week, 3 women have accused the governor of either sexual harassment, unwanted sexual advances, or other inappropriate conduct. 2 of them were employees of the governor. This is continuing to complicate a situation where we have 2 really crises that the governor is facing simultaneously: nursing homes and this sexual harassment. And that is significant because we have a budget due, and that is usually his thing that he does. The governor has significant power of the budgets, and we also have big questions remaining. Questions about the vaccine rollout, questions about schools reopening, the questions that Adam went through about the travel advisory and about quarantine guidance. We haven't been receiving the same information from the state government that we had up until these crises broke out. So we will continue to really take our scorched earth approach and look at as much stuff as we can. Pull up every local health department website to see what we can find for the latest and greatest. But that's what's going on in Albany.
Katie, thank you. I think that we're seeing a slowdown. You mentioned it, Adam mentioned it. I mean, at the beginning, we weren't getting as much out of the CDC. Now we're getting more updates periodically, and New York is slowing down probably for a variety of reasons. But we'll keep on it. I want to thank everyone for being with us today and for being with us every week. Please stay safe in the coming week, and we'll see you again next Tuesday.